behold, in the course of this judgment, while analyzing the reasoning of the majority and minority in P.V. Narasimha Rao, we have independently adjudicated on all aspects of the controversy, namely, whether by virtue of Articles 105 and 194 of the Constitution, a member of Parliament or the Legislative Assembly, as the case may be, can claim immunity from prosecution on a charge of bribery in a criminal court. We disagree with and overrule the judgment of the majority on this aspect. Our conclusions are thus. 1. The doctrine of stare decisis is not an inflexible rule of law. A larger bench of this court may reconsider a previous decision in appropriate cases, bearing in mind the tests which have been formulated in the precedents of this court. The judgment of the majority in P.V. Narasimha Rao, which grants immunity from prosecution to a member of the legislature who has allegedly engaged in bribery for casting a vote or speaking, has wide ramifications on public interest, probity in public life, and parliamentary democracy. There is a grave danger of this court allowing an error to be perpetuated if the decision were not reconsidered. 2. Unlike the House of Commons in the UK, India does not have ancient and undoubted privileges which were vested after a struggle between Parliament and the King. Privileges in pre-independence India were governed by statute in the face of a reluctant colonial government. The statutory privilege transitioned to a constitutional privilege after the commencement of the Constitution. 3. Whether a claim to privilege in a particular case conforms to the parameters of the Constitution is amenable to judicial review. 4. An individual member of the legislature cannot assert a claim of privilege to seek immunity under Articles 105 and 194 from prosecution on a charge of bribery in connection with a vote or speech in the legislature. Such a claim to immunity fails to fulfill the twofold test that the claim is tethered to the collective functioning of the House and that it is necessary to the discharge of the essential duties of a legislator. 5. Articles 105 and 194 of the Constitution seek to sustain an environment in which debate and deliberation can take place within the legislature. This purpose is destroyed when a member is induced to vote or speak in a certain manner because of an act of bribery. 6. The expressions anything and any must be read in the context of the accompanying expressions in Articles 105(2) and 194(2). The words in respect of means arising out of or bearing or a clear relation to, and cannot be interpreted to mean anything which may be even have a remote connection with the speech or vote given. 7. Bribery is not rendered immune under Articles 105(2) and the corresponding provision of Article 194 because a member engaging in bribery commits a crime which is not essential to the casting of the vote or the ability to decide on how the vote should be cast. The same principle applies to bribery in connection with a speech in the House or a committee. 8. Corruption and bribery by members of the legislatures erode probity in public life. 9. The jurisdiction which is exercised by a competent court to prosecute a criminal offense and the authority of the House to take action for a breach of discipline in relation to the acceptance of a bribe by a member of the legislature exist in distinct spheres. The scope, purpose, and consequences of the court exercising jurisdiction in relation to a criminal offense and the authority of the House to discipline its members are different. 10. The potential of misuse against individual members of the legislature is neither enhanced nor diminished by recognizing the jurisdiction of the court to prosecute a member of the legislature who is alleged to have indulged in an act of bribery. 11. The offense of bribery is agnostic to the performance of the agreed action and crystallizes on the exchange of illegal gratification. It does not matter whether the vote is cast in the agreed direction or if the vote is cast at all. The offense of bribery is complete at the point in time when the legislator accepts the bribe. And 12. The interpretation which has been placed on the issue in question in the judgment of the majority in P.V. Narasimha Rao results in a paradoxical outcome where a legislator is conferred with immunity when they accept a bribe and follow through by voting in the agreed direction. On the other hand, a legislator who agrees to accept a bribe but eventually decides to vote independently will be prosecuted. Such an interpretation is contrary to the text and purposes of Articles 105 and 194. We provide an overview now of the history of parliamentary privilege in India, followed by the purport of the privilege in India. I will read a few extracts from the judgment and the test to be applied. While some cherished freedoms exercised individually by members of the House, including the freedom of speech, have been undeniably understood to be essential to the functioning of the House as a whole, such exercises, such as damaging public property or committing violence are not and cannot be deemed to have immunity. The privileges and immunities enshrined in Articles 105 and 194 of the Constitution with respect to houses of parliament and the legislatures, their members and committees, respectively belong to the House collectively. The exercise of the privileges individually by members must be tested on the anvil of whether it is tethered to the healthy and essential functioning of the House. The evolution of parliamentary privileges, as well as the jurisprudence of this court, established that members of the House, or indeed the House itself, cannot claim privileges which are not essentially related to their functioning. To give any privilege unconnected to the functioning of the Parliament or legislature by necessity is to create a class of citizens which enjoys unchecked exemption from ordinary application of the law. This was neither the intention of the Constitution nor the goal of vesting Parliament and legislatures with powers, privileges, and immunities. We therefore hold that the assertion of a privilege by an individual member of Parliament or legislature would be governed by a twofold test. First, the privilege claimed has to be tethered to the collective functioning of the House, and second, its necessity must bear a functional relationship to the discharge of the essential duties of a legislator. We then proceed to apply the above exposition of law to the context of a legislator who receives a bribe to cast a vote or speak in a certain direction. We hold that bribery is not protected by parliamentary privilege for the following reasons. The words anything and any, when read with their respective operative words, mean that a member may claim immunity to say as they feel and vote in a direction that they desire on any matter before the House. These are absolutely outside the scope of interference by the courts. The wide meaning of anything and any, read with their companion words, connotes actions of speech or voting inside the House or committee, which are absolute. The phrase in respect of applies to the collective phrase anything said or any vote given. The words in respect of means arising out of or bearing a clear relation to. This may not be overbroad or be interpreted to mean anything which may have even a remote connection with the speech or vote given. We therefore cannot concur with the majority judgment in P.V. Narasimha Rao. The purpose and object for which the Constitution stipulates powers, privileges, and immunity in Parliament must be borne in mind. Privileges are essentially related to the House collectively and necessary for its functioning. Hence, the phrase in respect of must have a meaning consistent with the purpose of privileges and immunities. Articles 105 and 194 of the Constitution seek to create a fearless atmosphere in which debate, deliberations, and exchange of ideas can take place within the Houses of Parliament and the state legislatures. For this exercise to be meaningful, members and persons who have a right to speak before the House or any committee must be free from fear or favor induced into them by a third party. Members of the legislature and persons involved in the work of the committees of the legislature must be able to exercise their free will and conscience to enrich the functionings of the House. This is exactly what is taken away when a member is induced to vote in a certain way, not because of their belief or position on an issue, but because of a bribe taken by the member. Corruption and bribery of members of the legislature erode the foundation of Indian parliamentary democracy. It is destructive of the aspirational and deliberative ideals of the Constitution and creates a polity which deprives citizens of a responsible, responsive, and representative democracy. Under Section 7 of the PCI, the mere obtaining, accepting, or attempting to obtain an undue advantage with the intention to act or forbear from acting in a certain way is sufficient to complete the offense. It is not necessary that the act for which the bribe is given be actually performed. The first explanation to the provision further strengthens such an interpretation when it expressly states that the obtaining, accepting, or attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by a public servant has not been improper. Therefore, the offense of a public servant, being bribed, is pegged to receiving or agreeing to receive the undue advantage, and not the actual performance of the act for which the undue advantage is obtained. Indeed, to read Articles 105.2 and 194.2 in the manner proposed in the majority judgment results in a paradoxical outcome. Such an interpretation results in a situation where a legislator is rewarded with immunity when they accept a bribe and follow through by voting in the agreed direction. On the other hand, a legislator who agrees to accept a bribe but may eventually decide to vote independently will be prosecuted. Such an interpretation belies not only the text of Articles 105 and 194, but also the purpose of conferring parliamentary privileges on members of the legislature. Finally, before concluding, we hold that elections to the Rajya Sabha fall within the remit of Article 194.2. We hold, distinct from the marginal note, in the text of the provision, there is a conscious use of the term legislature instead of the House of Legislature at appropriate places. It is evident from the drafting of the provision that the two terms have not been used interchangeably. The first limb of Article 194(2) pertains to anything said or any vote given by him in the legislature or any committee thereof. However, in the second limb, the phrase used is in respect of the publication by or under the authority of a house of such a legislature of any report, paper, votes, or proceedings. There is a clear departure from the term legislature, which is used in the first limb, to use the term house of such legislature in the second limb of the provision. It is clear, therefore, that the provision creates a distinction between the legislature as a whole in the first limb and the house of the same legislature in the second limb. The elections to the Rajya Sabha conducted under Article 80, as referred to above, may also take place when the House is not in session, as seats may fall vacant when the Legislative Assembly of the state is not in session. However, the elections remain a part of the functioning of the legislature and take place within the presence of the Legislative Assembly. Similarly, the elections for the President of India under Article 54 and for the Vice President under Article 66 may also take place in Parliament or the state legislative assemblies when they are not in session. However, they are an integral part of the powers and responsibilities of elected members of the Parliament and the state legislative assemblies. The vote for such elections is given in the legislature or Parliament, which is sufficient to invoke the protection of the first limb of Articles 1052 and 194(2). Such processes are significant to the functioning of the legislature and in the broader structure of parliamentary democracy. There appears to be no restriction, either in the text of Article 1052 or Article 194(2), which pushes such elections outside of the protection provided by the provisions. Further, the purpose of parliamentary privilege to provide legislators with a platform to speak and vote without fear is equally applicable to elections to the Rajya Sabha and elections for the president and the vice president as well. So we have overruled the judgment in P.V. Narasimha Rao.
Should go there. The court never passes the buck, my lord, it only passes the parcel.
After this signed, I'll tell you a little aside on this. The members of the bar will be happy to. And it's just a little. We always to see them. Now I'll tell you the little aside. When we sit in a bench of 5, when we sit in benches of 2 or 3, even there, when we enter in court, the usher will always tell us who has to go in first. In some courts, the senior goes in first. Some courts, the junior goes in first, depending on the configuration. In combinations of 5, 7, and 9, it becomes a little more complex. So when 9 of us assemble, the ushers, there's a lead usher who will say, "Pehle aap jayenge." So we all stand in that order, subject to the ushers to the usher's command, and then we go in that order into the court.
As one of the few members of the bar who has seen Kesavananda Bharti being argued, Millards, as a student,
Yes.
there was a great sequence there, Millards, as the judges came. Grateful, Millards, grateful, grateful.